right, good morning, everyone. As I said, I am Professor Turezyn, and I've been teaching law school for 34 years. And while my upper level courses have changed, the one course that I have taught every one of those 34 years is I teach a required course to the incoming first-year law students. And I always tell them at the law school that the day they take that course away from me is the day I retire, because I absolutely love teaching the brand new law students. So welcome. Just think, a year or two or three, you could be sitting in my class in the fall. Now, last night I held some office hours at night. We have an evening section. And I do try to accommodate my evening students by occasionally holding Sunday office hours or holding office hours at night, because they have very complicated schedules. And it just so happened, two of my students there told me when I mentioned where I was going today, they said, "Oh my God, Professor T, I did that 2 years ago. I did that 3 years ago. I went to that and I remember seeing you there." So, like I said, that could be you in the not too distant future. I'm going to run a mock class this morning. I'm going to do it shorter than we would spend in my regular class, but I want to give you an idea of what law school is like. And to do that, I brought a case, an actual case that we would do. Would you mind helping me hand out some of these to some people over there? And here, would you mind helping me hand out, and some for you, hand out, and here, do you mind? Thank you. What I'm going to do is ask you to read those cases, read the case. You can take a few notes on the side, you can underline things, but I'm going to give you 5 minutes, actually 6 minutes, so we'll go to 11:15. Read it so that you can discuss it with me. Because one thing about law school is that we don't like to lecture. We like to extract what is important about the case from classroom discussion. So it's really critical you read the case, understand it, to the extent that you can. All right, let's get started. If you were in my law class, you would be getting this case about the 4th week of law school. We would have spent the first 3 weeks talking about something called intentional torts. I am a professor who teaches torts. Tort law is civil law. It is when you are suing someone for damages. Now, there's all aspects of civil law out there, but early on, the focus of the course is negligence. So I would have just about introduced the topic of negligence to the students, and we would have talked, well, what does it mean to be negligent? And we would have said that, generally speaking, in order to avoid being adjudged negligent, you have to act as the reasonable person under the circumstances. Now, I often, and I'm afraid I will lapse into it now, so I need to introduce this concept to you. We talk about negligence as what the ordinary, reasonable, prudent person under the circumstances would do or wouldn't do. I refer to the ordinary, reasonable, prudent person as ORP. So if you hear me use that acronym ORP, you'll know I'm referring to this ordinary, reasonable, prudent person. Now, here's a tip. ORP does not exist. ORP is a myth. He makes the lives of the rest of us mere mortals very difficult, because he, and I only refer to him as that because that's typically how we have, but it's he, she, it, they, whatever you want to say, always does a foreseeable thing. He makes a reasonable response. It may be from the position of a Monday morning quarterback. That is, when you can look back, you could say, well, you could have done something better. That's fine. But ORP doesn't necessarily do what's best. ORP does what's reasonable. So that's the standard. All right, so we would have done a couple of cases introducing this, and then we would get into this case. Now, who would like to talk about this case? Do I have a volunteer? Mr. Kevin. Mr. Kevin, stand up. The first thing you discover in Professor Turezyn's class is that when you are called on to give a case, and I don't usually call on volunteers, I cold call, but I was nice. When you are called to give a case in my class, you stand. Now, why would I make you stand? Is it because I like nothing better than to scare you to death, letting you know that not just me, but the eyes of all your colleagues are on you, hanging on every word, and by God, you don't want to mess up? Is that what this is all about, making you miserable? Well, some of my students think that's part of it, but it isn't. Why do you think that I want my students to stand up when I'm going to call on them to give the case? What might be some of my motivating factors? And this time, when you raise your hand, you don't have to stand up, because now you're just answering general questions. Yes, sir?
You don't have to stand in court.
Certainly, one of the things I point out is that if a judge addresses you or you address a judge, you better hop on your feet, because the judge will dress you down for failing to be respectful. So think of me as the judge. Get on your feet. What's another reason? Why else might I want you to stand up in front of all your colleagues to discuss the case? What does a lawyer do? Exactly. Lawyers have to speak in public all the time, whether it's the courtroom, in front of other individuals, whatever. And I want you to get used to thinking on your feet. Because again, in the courtroom, but elsewhere too, you're going to be peppered with questions, or you're going to have to think of objections, or you're going to have to answer the other side's objections. So I like my students to get used to thinking on their feet. Is it harder to think on your feet than when you're sitting down? Of course it is, yes, because when you sit down, if you don't know the answer and I'm peering right at you, your friend here says, oh my God, there, but for the grace of God go I, and out of the side of the mouth, she's trying to whisper to you the answer. If you stand up, stand up. How much harder is it for her to help you out? Now again, it's not because I don't want you helped out, but I want you to think about, how do I respond to these questions? All right, now thank you, Mr. Kevin, for agreeing to be my first volunteer. Now, let's talk about this case. What are the facts of the case? What happened in this case?
The facts were that the victim at the time was waiting for his cab when he was robbed at gunpoint by another man, who then proceeded to take his cab, essentially hijack it, forcing the cab driver to exit the cab, which also caused several other injuries in the process.
Now let's go back for a minute. You said the victim here. Who is the party who's suing?
I was never exactly clear on that point.
Who is the party who's suing?
The person who was injured from the cab.
Who was the person who was injured?
It's a woman and her child.
Right, were they in the cab?
No.
Were they the guys with the guy with the gun? Who were the plaintiffs?
They were on the call when they were doing stuff.
Yeah, talk about being in the wrong place at the wrong time. They were simply out on the street. All right, so they would be what we call the plaintiffs. The plaintiffs are the people suing for damages. Who's the defendant in the case? Who do we want to extract money from at the end of the day?
The one who was robbed a man at gunpoint, hijacked the taxi, and hit the innocent bystanders.
Boy, wouldn't that be great? Because after all, who was ultimately at fault in this case? Who was the bad guy?
The robber.
Exactly. And so if you are the attorney and these people walk into your office and they tell you this story and they say, you know, we want money damages for what happened, you're going to suggest that they go after that robber, right? Really? First place, is the robber the defendant? That's what we call. No.
The defendant is the cab driver.
The defendant is the, well, it's actually not even the cab driver. Who is the defendant? Who is the defendant? It's not the cab driver, it's his.
The cab company.
Yes, exactly. We'll come back to that in a moment. But imagine that you've just told, your clients have just told you this story. And of course, they're all angry at the guy, the robber. Why aren't you pursuing the robber? Why aren't you, yep, absolutely, we are going to go after that robber. We are going to make sure that you're compensated?
Because the robber's not the one who was in charge of the cab.
Well, that's true, but certainly if the robber hadn't jumped in there with the gun, this wouldn't have happened.
The robber doesn't have money.
What makes you conclude the robber doesn't have any money?
Literally by the fact that he robbed.
Exactly. You want somebody who's going to have some assets. Now, I'm just, thinking out loud here, but if you are a robber, you probably don't have the kind of assets that we would be able to go after should you not have any money. Now, of course, if you're a robber, though, you would always take the precaution of making sure you have car insurance, right? Right, because you're a law-abiding citizen, except for the fact that you rob. So, yeah, there's some real problems. Not only that, not only might he not have assets to go after, where might he be? Jail. Again, while it's nice because we would always know where to send a subpoena, should we want him, he's not going to be much of an asset if we want our clients to be compensated for what they suffered. So instead, the party that we are going to make the defendant is not the cab driver, but the cab company. Now, again, why would we do that? Why not go after the cab driver?
Because the company has more money and they hired the cab driver.
So we have the deep pockets theory. This is a theory known in law, but you'll see it bandied around a lot, called respondeat superior. Let the master answer for the acts of his servant. The cab company will be responsible for the torts committed by cab drivers within the course of their employment. Now, there's no evidence that the cab driver was acting outside of his employment. He was out there looking for fares. So the cab company will be liable, but only if what? In order to keep the cab company liable, what must you prove?
That the driver acted negligently?
Yes, absolutely. So at the end of the day, it looks like we've got somebody who's got a fair amount of money, probably insurance. So we would say to our clients, we're going to go after the cab company. And at first they might be a little surprised by that and say, well, why aren't we going after the robber? All right, why aren't we going after the cab guy? And you explain why. But ultimately, our case rests upon a finding that the cab driver was negligent. Now, why would the plaintiffs contend that our cab driver did not act as the ordinary, reasonable, prudent person? What acts do they point to that they say, oh, this shows he is not the ordinary, reasonable, prudent person?
He was being held at gunpoint at the time that it was happening.
Is that what our plaintiffs are going to want to make sure the court's aware of? Remember, our plaintiffs want to make sure that the court thinks he deviated from the standard of the ordinary, reasonable, prudent person. What acts do they say show he did not act as the reasonable person? What did he do?
Jumped out of the cab.
Not just jumped out,
Opened the door, slammed the brakes, and then jumped out of the cab.
and the cab was
The rest of them was inside.
still moving. Now, ordinarily, if you were a young attorney and somebody came into your office and said, I was run over when the driver of a vehicle jumped from that vehicle while the vehicle was still in motion, got out, and the car veered over and ran over me, you'd say, this is obviously an easy case. Cha-ching, we are going to win this case. And so in this case, I presume that the plaintiffs prevailed, they got money, and everyone went home satisfied. Did the plaintiffs win? Did they prevail? They didn't prevail?
No.
Why not, Mr. Kevin?
I mean, to get I guess for the general purposes of it, they didn't have the burden of proof needed to actually prevail for the case.
Well, they didn't meet their burden of proof. Yes, they didn't meet the burden of proof to establish that the cab driver was
Negligent.
How could you fail? My God, you must have been a terrible lawyer if you can't show that jumping out of a vehicle while it's still moving and letting it go off is not negligent. You must be a terrible attorney. Right? I mean, you just don't jump out of a moving vehicle, right? The ordinary, reasonable, prudent person, Orp, would never do that. Never, ever, ever, right? Orp would never.
But who saw that gun?
Oh. Oh. So when Orp is deciding how to act, is Orp allowed to take his own safety into consideration? We don't allow that, right? Of course not. We are all about serving humanity. You wouldn't put your own personal safety above some strangers, would you? No. Really? I'm not driving with you. All right. Would the ordinary, reasonable, prudent person consider his own or her own safety? Yes, and you are allowed to. We once had a case where a driver was stopped at the bottom of a very long hill at a light, and he was stopped there, and he said he looked in his mirror and he realized that there was a truck, an 18-wheeler, coming down the hill, and he said, I knew that truck's brakes were not holding. He said, I could tell just by, it was picking up speed, it was coming, so he pulled out of the way. The truck did not have any brakes, and it hit the car that was in front of him. The car that was in front, the driver was obviously seriously injured, and so were some of the passengers. Not only, though, did they sue the truck, where the brakes failed, but they sued our driver, saying, well, if you hadn't moved out of the way, we wouldn't have been hit, or we wouldn't have been hit anywhere near as severely. And we got him dismissed from the case on the idea that, wait a minute, you are allowed to take yourself into consideration. So, our driver here is presented with what? Now, what happens? Now let's get to the heart of the story. What are the interesting facts in this case? It's early in the morning. Where? Where's this case take place?
In the alley near 26th and 3rd Avenue, Manhattan.
But I mean, yeah. Okay, so we're in New York City early in the morning, and what happens?
The man's waiting for his car, or the taxi, when he's brought into the alley and is robbed at gunpoint.
Okay, somebody is robbed at gunpoint. Then what happens? How many robbers are there? 2, okay? So 2 robbers rob X at gunpoint. Do we ever hear what happens to X? No, he becomes just an extra on this drama. All right, now what happens? We've just taken his money, his watch, whatever.
The 2 robbers split up. One decides to take the cab that the person was waiting for, and that's the person with the gun.
Now, when you say he takes the cab, I'm not sure what you mean by that.
Hijacks.
Does he hijack the cab? Does he say, get out to the driver and start driving the cab?
No, he forces the driver to drive.
Okay, and when you say forces him to drive, what kind of force did he use? What persuasive power did he exhibit that would get the guy to drive?
He used his firearm to threaten the driver.
Yeah, put it in his back and said,
To essentially blow his brains out if he didn't drive.
okay. Now, not too surprisingly, the cab driver complies. So he starts to drive. Now, meantime, what's going on? Outside the cab, what's going on?
You want me to keep going?
What's going on?
Obviously, there's a little bit of chaos.
Chaos from where? From whom?
The person who's just robbed.
He starts yelling, screaming. And what happens when he starts yelling and screaming?
He gets the attention of the police officer.
Well, I don't know about a police officer, but other people, right? And now what do they all start doing? What are these people doing? These cases have to be read very, very, very carefully, because I would want you to know all these facts. Obviously, you had 5 minutes to read it. I don't have the same expectation. But all these people, what do they start doing? After they make sure the guy's all right, they start chasing. First, they chase the robber. He jumps into the cab, and then they start chasing the cab, right? So figure this out. Here we have a cab, where the driver's got a gun to his back. We've got a guy in the back with the gun. We've got people chasing the cab. Stop, stop, stop. And of course, we have our cab driver. And at that point, what does our cab driver do?
He slams on the brakes and exits the vehicle.
Yeah. Now, ordinarily, is it a smart thing to do? Just forget other people. Is it a smart thing to do for the person to jump out of a moving vehicle?
Not necessarily.
Yeah, why not?
Because there's a lot more danger in moving out of a moving vehicle.
Sure. I mean, ordinarily, not only do you put others in danger, but you would put yourself in danger. All right, he jumps out, and what happens to the vehicle? What happens to the cab?
It veers off onto the sidewalk and hits the mother and children.
All right, so they are the ones who will become our plaintiffs. Ultimately, they catch the bad guy. But that's not whom we are pursuing. We are pursuing for money damages the cab company on the theory that the cab driver was negligent under the circumstances. Was the cab driver negligent under the circumstances?
No, he was not.
Why?
Because he was looking out for his own life.
Well, now if I had caused the problem, let's say I was driving erratically and I put someone in danger, can I just say, well, I'll jump out now because my driving isn't so good? No. He was faced with something not due to anything he caused, but from an outside party. In fact, he was faced with probably the most serious thing one can be faced with, a gun, right? And what's he afraid is going to happen to him at any minute?
He's gonna get killed.
Why would he think that? Is the guy seemed to say, look, drive, you know, I'm not going to fire the gun if you drive. Wouldn't that make you feel better? Why not?
Still a gun.
But the guy said drive. He didn't say, you know, I'll blow your brains out now. He said drive or I'll blow your brains out. So don't you feel much more secure knowing that you're driving? No, of course not. He sees his opportunity and he seizes it. He jumps out. Okay. What was your opinion of the writer of this opinion?
It seems like he paints a very broad picture that kind of always alludes to like the taxi driver, and it never really incorporates like what's going on really with him too much. I feel like with a lot more emphasis on the taxi driver, I feel like this could have been like less of a bigger case.
What do you mean a bigger case?
Well, forgive me, it's all on the spot, but
No, in my class, I'd be standing here. So I'm giving you some space here. Yes, I understand completely.
It essentially seems that a lot of what the taxi driver was tasked with doing was so fast and it was so hard to think about that it wasn't necessarily fair that a lot of this case hinges on him.
Well, we know who the really bad guy is here, but we already realized why we're not going to bother pursuing him. But the question is, did he act negligently? But I'm referring now just to the opinion. What did you think when you read this case? Be honest. What did you think when you read this? The writing, the prose, you didn't think, this is a little strange.
It was almost like reading like a novel. It was very vivid.
Very vivid.
Yeah.
A lot of multi-syllabic words. A lot of references to whom? Great literary characters, right? Great literary works. Do you think this is what most judges write like? This is the only case that's anything like this in our textbook of over 2,000 pages. And I've read a lot of opinions, but I have never read one quite like this. This seems to be a judge who's a frustrated fine arts major in undergrad, went to law school and says, aha, here is my chance to show the world what I actually know about something besides the law. But the judge does have to answer the serious question. Was the taxi driver negligent in jumping out of a vehicle?
No.
Why not?
Because due to the totality of the circumstances,
He acted
reasonably.
reasonably. Yeah. Now, just in the air, just if I were to spell out the factors as I would if I were the plaintiff's attorney, I would say this is a case where the defendant suddenly jumped out of a moving taxi cab, went to the side of the road, and the taxi veered off and hit the plaintiffs, and therefore we should recover. And on superficially, as I've laid out the facts, it'd be kind of hard to disagree that the guy was negligent. But you always need all the facts. That's what we talk about, the reasonable person under the circumstances. And what are those circumstances? Here, it includes the fact that the defendant,
He's being held at gunpoint.
right, you are allowed to think about yourself. Despite the fact that the court, in fact, fines for the defendant, what does the court say about the taxi driver? More than one time. He suggests that some may call him a... Who said that? Yeah. Court says, while some may refer to him as a coward. And court says that a few times. Court also suggests that our taxi driver is not very what? Intelligent. Where did you get that idea? What specifically does the judge say? Anybody have it?
As horrible to a humble chauffeur as it undoubtedly would be to one of intelligentsia.
Well, a member of the intelligentsia. Yeah. Man, talk about a diss in the middle. Now, you're right. It's not right out there. It's not the first sentence. But it says, well, it must have been bad for you, like it would have been bad for somebody who was intelligent. And by the way, what does he say about cab drivers? What don't they have any knowledge of, according to this judge? What don't they have any knowledge of? Unlike intelligentsia, the humble chauffeur doesn't know about Hamlet's ghost and Charybdis and Civilis, all these highfalutin names. Why? Why does the judge think the cab driver doesn't know about all that stuff? What does he think of the cab driver in his elitist mind?
He's unintelligent.
He's unintelligent, a laborer, not at all like those of us of the intelligentsia, because I'm sure he puts himself in that class. Well, I go to New York very frequently, and when I read this case, I laugh, because when I take taxis, I almost always engage with the taxi driver because they're fabulously interesting. They really are. They'll talk about some of the great fairs they've had, or they'll talk about police chases they've been, all kinds of really interesting things. But frankly, a lot of them have masters in fine arts degrees, or they are actors who've gone to Yale and are still waiting for their big break on Broadway. So I don't think the judge actually has a good idea of the kind of individual we could be talking about. But that aside. All right, you are the attorney for the defendant. You've won the case. Woohoo! You find out you've won, the opinion is sent to you, or you get it online today, or whatever it is. Now, obviously, you're going to call the cab company and say, hey, I've got good news. We won the case, and, they have 30 days to appeal. We'll see how it goes, but right now, everything's okay. You won. Good for you. Would you send a copy of this opinion to the cab company?
So right now, I don't see why I wouldn't.
There's no right or wrong answer here, but as a lawyer, I want you to think about some things. Usually, especially if you win, you send the opinion right away. Whoo-hoo, we won. But even if you lost, you want to send it with, here's why and here's how we're going to appeal it. But I'm not sure that I would be as excited to send this opinion to the cab company as I might some other opinions. Why?
I guess it's kind of degrading to the cab drivers and
Yes, it's certainly, and he knows nothing about this particular cab driver. He's definitely, basically defaming a whole group of individuals. So I'm not sure that the cab company, who probably isn't involved in the legal system every day, like we lawyers are, like judges are, stuff like that, I'm not sure I'd want him to read this opinion, because it does seem to me that although the judge ultimately fines for our cab driver, he does suggest that our cab driver may have been a little bit of a coward, right? Now you're the attorneys for the plaintiffs. You've lost. You got to call them up. You have to say, look, mother, 2 children, your damages, the court found that the cab driver acted reasonably under the circumstances. A lot of times you will send the opinion to your clients. Would you be eager to send this opinion to your clients, the plaintiffs who lost? Would you?
No,
Why not?
because it brings up the fact of whether it gives him another time to sue the judge and how he talked degradingly.
Can you sue the judge?
Yes, because he's, I won't say belittling, is there something of character, I forgot the word.
Can you sue the judge? Absolutely not. Anything that goes on in the course of the judicial proceeding is going to be privileged for purposes of defamation or something like that. But would you want to share this with your client? I think your instincts are correct. Is this something you'd want to share with your client? Would you? You would. You wouldn't mind. Okay, that's fine, because like I said, usually you do this. Does anybody have a different view?
I think it's a sensitive issue, especially since the plaintiffs were injured. And, you don't want to just send something like that to them. And
Why? What does the judge kind of make of this whole case, as evidenced by his opinion?
pretty cavalierly.
Yes. Yes. When my law students read this case, at first they're all chuckling and everybody wants to give it because they think it's a fun and funny case. They're like, what's with this judge and, all these references and stuff like that. And we kind of laugh about it. But at the end, I really ask these last 2 questions. If you're the defense, would you send this opinion to your clients? And at first, most people say, yes, I won. But then we talk about it a little bit. I mean, you won, yes, but it's not like the judge said, oh, your clients were so heroic considering a gun was at. I mean, he was pretty tough. And he said they're not a member of the intelligentsia and they don't know all these literary references. And then we come to the plaintiff. The plaintiff's lost. Remember, we have a mother and children who were injured. Now, twice in the opinion, the court says the injuries were not great. Still, I would be very concerned that if my clients read this opinion, would they think that the judge took their case seriously? It really seems like he paid no attention to them. He doesn't say anywhere what their injuries are. We have no idea. So when we study law, we don't only just study the opinion, what the law is. We study what the law does, what it presents to the community, both good and bad. Thanks, Mr. Kevin. Do I have questions? does anybody have a question either about law school, how it's taught, or the case?
Do you normally give out the cases beforehand?
Oh, you have a
Yeah,
case book,
okay.
and yes, that's what I said. I realized Mr. Kevin was very kind to do this because you would get assignments ahead of time, and I would expect you to do what we call a brief of the case. You'd put the facts, the issues, the holding of the law, the rationale, so that while I want you to be able to have a discussion with me, I want to parry back and forth, I want to be able to ask you questions, you at least would be prepared for the very basic stuff that I could ask. Okay, Dean Ayers?